Hello. Now we have WME's motion for continued sealing. So there are attachments to this filing, as there are for others like John's Works and the case in Coslow and a few others. I will do separate videos for the exhibits, just in case they're like, takes us into quite long exhibits. I know Jed Wallace's these exhibits alone were 63 pages. So, and he had a 9-page motion. So, I've chosen to just do the separate motions, the letter motions, and then do exhibits as a separate video for each party or non-party in this case. This is WME's motion to seal. There's some really interesting exhibits attached to this. So I will probably do them next actually, and then go on to the lively motion. Okay, let's get into this letter. It's 4 pages long. Okay. Dear Judge Lyman, pursuant to Rules 1C, 2H2, and Attachment A of Your Honour's individual practices in civil cases, non-party William Morris Endeavour Entertainment respectfully request that this court order the continued sealing and redaction of certain confidential, personal, and non-public information contained in certain exhibits attached to Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, Ainsworth's Movie, Melissa Nathan Tagg, and Jen Abel, collectively the Wayfarer parties, motion for summary judgment, and Blake Lively's opposition to the Wayfarer parties, motion for summary judgment. Both motions attach as exhibit materials that were produced by WME in discovery that were designated as confidential. WME's proposed redactions are available in exhibits to this letter motion. Okay. So, 1. Standard. In determining whether sealing is appropriate, courts in the Second Circuit apply a 3-part test. First, courts determine whether the documents at issue are in fact judicial documents to which the presumption of access attaches, meaning that the documents are relevant to the performance of the judicial function and useful in the judicial process. Second, if the documents at issue are judicial documents, then courts determine the weight of that presumption of access, which varies based on the document's importance to the judicial function and its value to those monitoring the federal courts. Third, courts balance competing considerations against the presumption of access, including the privacy interests of the person resisting disclosure. Okay. Such interests establish a venerable common law exception to the presumption of access. Non-party WME's privacy interests outweigh the public interest in the redacted information. In evaluating non-party privacy interests, courts consider both the degree to which the subject matter is traditionally considered private rather than public, as well as the nature and degree of the injury to which the party resisting disclosure would be subjected were the privacy interest not protected. The latter inquiry entails consideration not only of the sensitivity of the information and the subject, but also of how the person seeking access intends to use the information. For example, courts have the power to ensure that their records are not used to gratify personal spite or promote public scandal, and have refused to permit their files to serve as reservoirs of libelous statements for press consumption. So let me just summarize what that means. They don't want their private text messages coming to people like me or other content creators, because we may talk about them on our channel and it may not be the most flattering. That is all that is. I mean, there is, no, it's just ridiculous. It's not like Wayfarer are going to, there's no insinuation that Wayfarer are going to use these messages like for personal spite or to promote a public scandal. I'm not sure this should wash. I don't think it should wash myself. And this is why. Because just because you may have said something, which I bet I would absolutely wager that this is because the messages in they're talking about here are actually Danny Greenberg, who was Justin Baldoni's agent, and they are text messages predominantly between Danny Greenberg and Justin Baldoni, talking about basically Blake Lively taking over control and what a shithead she is. They don't literally use that term. It's just, that's me. And they're saying, well, if this gets out into the public, it's going to embarrass us, and it might make Miss Lively, it might reveal her true colors and what we really think of her, so it will harm us. So we don't want that. That should not be enough for Lyman to keep this sealed. But let's continue. Here, WME's privacy interests justify the requested redaction of certain private information in internal WME text messages. I disagree. I do disagree. And we've also got to remember, whilst these messages are in the Lively Wayfarer case, we have to keep in mind at all times, when it comes to WME, there is an overlap because Stephanie Jones is married to like one of the senior executives, a partner at WME, Jason Hodes. So every time we talk about WME, we do have to bear in mind that, another party in a different lawsuit, a related lawsuit, but is technically a different lawsuit, Stephanie Jones, is married to someone who's high up at WME. Okay. The proposed redactions are narrowly tailored and seal only sensitive information that has, at best, minimal relevance to the court's summary judgment decision. Notably, there is no evidence that the WME employees participating in the communications have any personal knowledge of what happened during the filming of It Ends With Us, and in fact, they did not. Again, I disagree with that. They may not have been on set, but they were aware. They represented both Justin Baldoni and Blake Lively. They were well aware of what was going on. Instead, the basis of WME's knowledge in connection with the proposed redactions was statements and information conveyed by WME by Messrs. Baldoni and Heath without independent verification or investigation by WME. Thus, WME requests to redact statements that merely advance second and third-hand knowledge. Moreover, WME employees are agents and advocates for their clients, and the communications reflect advocacy based on information conveyed to such employees by their clients. Can I just point out, I'm going to go back here. I'm just going to go over this quote. Instead, the basis of WME's knowledge in connection with the proposed redactions was statements and information conveyed to WME by Messrs. Baldoni and Heath. So they're saying, well, Baldoni and Heath made these statements to us, told us that Lively was, a control freak and taking the movie from them. We don't know anything. They just told us that. We didn't do any investigation. Can I just remind everyone? WME also dropped Justin Baldoni based on nothing more than Lively's statements without any investigation. So when they're arguing and saying, well, we have no personal knowledge, they had knowledge enough when the statements were coming from Lively to have dropped Justin Baldoni. I feel like that we need to remind ourselves of this. We also have recording of Ari Emanuel stating as fact, not that he'd heard that Justin Baldoni was awful to Blake Lively or sexually harassed her on set. He stated as fact that he did do those things. That is recorded, him saying that. So how can they possibly argue that they have no personal knowledge? It's horseshit. Okay. As such, the proposed redactions constitute confidential communications made in an advocate capacity based on statements made by Messrs. Baldoni and Heath, which are not based on personal knowledge and therefore offer no independent corroboration. Accordingly, the redactions are inadmissible hearsay and thus ought not to factor into this court's ruling on the summary judgment motions. Right, okay, well, wouldn't that then also apply to people that Blake Lively is trying to bring into this? You know, such as Alex Sachs, such as Isabella Ferrer, such as Jenny Slate, you know? Like, if we're going to apply that principle, then that needs to apply to both sides. This is such a frustrating filing. These statements may, however, gratify private spite or promote public scandal if published without redactions, which is exactly what this court warned to avoid. Because the redacted material is largely collateral to the factual and legal issues central to the resolution of the Wayfarer Party's motion for summary judgment, the weight of the presumption of public access is low. WME's privacy interests are high, as the redacted material is not already public. Specifically, the redacted communications involve Patrick Whitesell, Endeavour's then executive chairman, who has had zero involvement in this litigation. Mr. Whitesell was not deposed, has not submitted a declaration, is not listed on the party's initial disclosures, and is not mentioned in either the party's pleadings or the party's summary judgment papers. Given the minimal relevance of the redacted material and WME's privacy concerns, unsealing these communications will merely further the media-driven nature of this case. WME thus respectfully requests that the court permanently seal the specific portions of Exhibit 155 and Exhibit 244 to the Wayfarer Party's motion for summary judgment and Exhibit 159 to Ms. Lively's opposition motion. Submitted herewith are redacted versions of Exhibits A to C. Additionally, WME understands that Ms. Lively intends to file a separate motion for the continued sealing of confidential information contained in certain exhibits. I do know those exhibits refer to Ryan Reynolds' communications with WME. Consistent with the privacy and relevancy grounds articulated above, WME joins in Ms. Lively's motion to the extent it seeks to seal confidential communications between WME employees and clients who are not party to this case. Specifically, WME joins in Ms. Lively's request to seal Exhibit 149, Exhibit 205, 207, 210, and 211, and the Wayfarer Party's motion for summary judgment and Exhibit D and Exhibit E to the Wayfarer Party's opposition to Ms. Lively's motion for Rule 11 sanctions. WME also joins Ms. Lively's motion to seal Exhibit 84 and Exhibit 85 to Ms. Lively's opposition to the Wayfarer Party's motion summary judgment, as these documents reflect WME's commission rate. This information should remain under seal or be redacted because it's not relevant to any disputed material issue in this case. Okay. Well, I've already given my opinion throughout the video, but I don't love this filing at all. I'll have to see how Wayfarer respond and what Lyman says, but this, like Isabella Ferrer's, I think is just ridiculous and has no real basis. Okay, so I'll do the exhibits in a separate video.